is the Morning Fix with Jeet.
Well, a very good morning to you. Right now in the studio, we do have the owner and the lead attorney of NRI, Legal Help NRI, Monisha Mahajan, in the studio with us. We're going to be talking about something extremely important. I know all of us have been through this problem, and of course, we know people who have been through this problem. So make sure you keep your ears glued to Radio 44, because trust me, this is the kind of information that will help you a lot in life. For now, we're getting back into the music, and Monisha will be joining us in just a few minutes. Keep it right here on Radio 44. Good morning to you. A very good morning to you. Hope you're having a fantastic morning. I got to tell you, I am geared up for mine right now. I have Monisha Mahajan in the studio. Welcome to the show, ma'am. It's always a pleasure to have you right here on Radio 44.
Thank you, Jeet.
How's everything with you?
Good, lovely cold morning here in Kenya.
Yes, indeed. Very cold. I like it. It's pretty chilly. Now, let's talk about this, all right? I think we were having this discussion off air as well, where a lot of people in India, or people who have property in India, they tend to, forget about that property. They think, okay, fine, it doesn't matter. And then over time, like you said, value appreciates so much to a point where now you're thinking, oh, wait, I can actually utilize that. And then, when you come to actually doing it, it's an entirely different story. Complications arise, and that's where experts like you come in. Okay, so let's go straight into it. What are the processes non-resident Indians need to follow, or non-residents need to follow in India to draft and execute a will?
Okay. So, Jeet, the will is the same world over. It's not like, what I consider will is the last wish of a person.
Yes.
Yes, with the value of the properties appreciating, the disputes arising after a person who's made the will dies, there are laws in India for doing up a will. Now, let's say whether it's non-resident Indians or Indians, the will, the format, the process for the will is the same. Only thing is that people who live in foreign countries or people living in other countries feel that if they've done a will in that country, now let's say people in Kenya, like I deal with it on a day-to-day basis, either
Yes.
people haven't made a will, or if they've made a will, they feel the will in Kenya can be executed in India.
Yes.
Now, of course, a will made in a foreign country can be executed. There are things that they need to consider. One, that it has to mention the Indian assets, and it also has to be done. It does not have to be a trust to be created. There does not have to be a trust created or whatever. It has to be very categoric that okay, after X passes away, the property in India will go to A, B, C, D.
Right.
Now, this is one thing that they need to establish, and they need to categorically mention in the will in Kenya. Now, the other thing is the two witnesses. Now, mostly I meet people where the will is not witnessed by anybody, or a will is witnessed by a lawyer who cannot 100% travel to India or be one of the witnesses to the will. Now, what has happened in India, because of again, like you said correctly, that the value, the real estate is appreciated so much that today the courts or any authority where there is a property and the property has to be transferred, they would ask you to go to the court and get an order from the court saying this will is a valid document, which we also call probate in some areas. Otherwise, it's just a declaration by the court. Now, if they're getting that will probated, they would want that witness to step into the witness box.
Okay, physically
present, an affidavit needs to be present, or if they it's a non-contested will, then it is an affidavit which can be done from this country. But more so, where I have seen till now, most of the wills are contested. So if it's a will contested, the witness has to step into the witness box, which means his presence in India is important.
It's a must, yeah, because it won't move forward without that witness.
Correct.
Good Lord. Okay. So now here's a question. Can non-residents appoint an executor for their will in India? And what are the key considerations one is supposed to, consider when doing so?
Yes. So executor, of course, they can appoint any executor, any person who's an executor but not primarily a beneficiary in the will can be an executor to the will. And yes, the key considerations, like I said, is that when they are making a will, they can make a will in Kenya. They can go to the Indian High Commission, get the will stamped, but the two witnesses who are going to be on the will have to be people who can travel to India in case required by the courts. And if the will is disputed, even if it's not disputed, if it's in a state like Maharashtra or Gujarat, the affidavit of the witness is required to be presented in the court.
So, wow. So that means any time that they're required to be there, let's say the witnesses are in a different country, maybe the will was prepared eons ago, wherever they are, every time they're needed in India, they need to be able to physically fly in and be there.
Yes. And Jeet, just here, I want to just take 1 minute here. Mostly what people feel is will is the safest document to do, because in different countries, it's a different way of doing things. In my opinion, in my experience of 20 years of doing this ongoing disputes with non-resident Indians for their properties, will is not a document which gives people rightfully what belongs or what the intent of the deceased person is. Now what happens is, it's like if the father is given property to the two sons, then the daughters can step in and say that even we have a right, with the 2005 Act coming in, that the daughters have an equal right in the ancestral property. If the father is given property to one son, the other son can step in and say that, okay, even I need a share in this property because this property is more expensive than what I have got in London or in Kenya, whatever. So what I feel for people who are living abroad and their children will not be able to go back to India, manage the assets during their lifetime, they should transfer their properties to their children in whatever way they can. But this is my advice to people who are living and who are hearing us today, that while you are living, distribute your assets in a way that your children don't curse you when they have to go to the court every time.
And Lord knows that anyone who has to go to a court keeps cursing. That's true. Okay, now are there any particular rules around the distribution of assets for NRIs in India, when people pass away?
Yeah, see, this is a myth that people feel that the next of kin is mostly the spouse.
Yes.
Whereas for the Hindus, it's the Hindu Succession Act. For the Muslims, it's the Muslim Personal Law which comes into picture. And then for the Christians and other religions, it's the Indian Succession Act. So the next of kin is not the spouse. Next of kin in India is all your legal heirs, which includes your children, your legitimate, illegitimate, or whatever, all your children, your widow, your mother, for the males.
Are you kidding me?
Yes.
So there's no spouse involved in there?
The spouse, number one, the mother of the son, it's a male. So let's say it's you, right?
Yeah.
Your legal heirs would be your mom, your wife, your children. All of them will get an equal share in the property. So if there are 8 of them, the property gets divided into 8 parts. And if there are 3, it gets divided into 3 parts. It's not because people feel that the mother doesn't have a right in India, but India, mother has a right to the property of a son.
Okay, so it's not like if I prepared a will and I said, okay, I'm giving it all to my wife. No, this is when you're talking about the will. No, I'm talking about natural succession. The natural succession. So if I hadn't prepared a will.
Yes. Okay. Now, but if you prepare a will, then all of them I will need. Let's say you wanted to give everything to your wife and your 5 children and your mom. Then I will need a no objection from all of them to say that the will is there. They have no objection to the will.
That's super interesting. See, now I didn't know that. Thank you for that. Well, this is super interesting. We will be getting back shortly. Remember, you can send in your queries as well. If you have any problems as well, send them in 0758 123 444. I think Monisha will be able to give you some advice right here. Keep it right here on Radio 44. And remember, you can watch the interview live on radio44.co.ke. Right now, dropping you this one by PBN and Balwinder Bhati and Gurlej Akhtar. It is a classic. It is Sadigal Horia playing right here. Here's Daniel and Techno with that ultimate worldwide hit, Booga, playing right here on Radio 44. And I got Monisha Mahajan, the owner and attorney at Legal Help NRI. I think you actually literally opened my eyes regarding a lot of things. And right now I'm just over here thinking, oh my God, what have I been thinking all this time? So this is really interesting. Now, what are some of the key tax implications for non-residents when it comes to wills and probates in India?
Okay, so in India, unlike UK, I don't even think that there's an inheritance tax in Kenya. But in London, yes, there's an inheritance tax. So for wills, a person can make a will. There are no tax implications because the concern for people is just the inheritance tax and nothing else. That if they have to get anything to their country of residence. So I don't think Kenya has inheritance tax, unlike the only country which I know of and where clients have an issue is UK. Otherwise, making a will is just making a will. It's only children who inherit or the people who are going to inherit are going to face the consequences.
Yeah, they have to pay for the taxes. All right. Now, how can non-residents ensure that their wills are recognized in India? I think particularly if there are conflicting laws or regulations in their home country, like let's say if someone in Kenya has conflicting laws over here, then how can they ensure things go well there?
Well, like I said, that the will has to be done in a particular way, like you do it as per prescribed process of law, making a will on a simple paper, witnessed by two people, stamped by the Indian High Commission. If not, you can go to India and get the will registered, because mostly people feel that a will is only a document accepted in India if it's a registered document.
Okay.
Even though it's a registered document, some parts of India do accept it for transferring the land on the basis of the registered will. But like I said, if it's challenged, it's challenged. So make sure that anywhere you do the will, whether it's getting it registered or getting it done by the Indian High Commission or consulate in your country, it has to be done by two witnesses, and those people should be in a position to travel to India.
Okay, now, this I'm just stepping in with something unique, because I just remembered one of my friends had mentioned this when he was going through a problem. I don't recall what exactly it was, but there was this thing where he mentioned there was some sort of a law where if someone was staying at a certain property for a very long time, they have some right to it. What is that exactly? Is that a myth?
No, that's not a myth. That's called, what do you call, the squatter's right, or
Yes.
the law of adverse possession. But we need a complete talk show on that.
About that one, yeah?
Yes.
Oh my God! So it is real.
It is real. It is
Oh,
real.
that is
So
super
that's.
scary.
I'll just quickly take that. So people who live in your property without any kind of, a title like of a tenant or a caretaker, it's like your relatives or somebody, some uncle, aunt have been living in a house for 12 years or more, and you've not asked them to move out, and they've been looking after the property, the electricity bill, the water bills are in their name. Yes, they can seek the ownership rights on the property.
Oh
Yeah, they
my
can.
God. Okay, we'll be coming back shortly. I just need to take a breather from that one. That's an ultimate shock. Keep it right here on Radio 44. For now, back into the music. Kanika Kapoor and Ravindra Upadhyay. I butchered it, didn't I? Just say it. Just go ahead and say it, Monisha. Say it again.
Upadhyay.
Okay, did I? All right. So yes, the lovely voice you're hearing right now is Monisha Mahajan. No, she's not here to teach me how to pronounce Indian names. We're talking about wills and probates. She is the owner and an attorney at Legal Help NRI. Thank you so much. I think you've helped me over there right now. Okay, so we're talking about one of the most complex situations, and this is regarding wills and probates. Now, what are the potential pitfalls that non-residents should be aware of when drafting a will in India?
Right. So what happens with people who are here feel that, a will is a simple document where they can just write, let's say, if Mr. Singh wants to give property to his two sons, but he's got 4 daughters, and he's got a widow from the third son also. What they do is they just mention the name of the 2 sons. They will never mention the rest of the legal heirs and why they are not giving the property to the rest of the legal heirs. So this is one of the major issues that, when a will gets challenged in India, this is one question is asked, that why did he not mention the rest of the legal heirs in that will, and why the reason for not giving them anything is mentioned in the will. So this is one thing I always suggest people, that list out all your legal heirs. The reason why you're not giving them assets should be categorically stated in that.
Okay.
This is one thing. Secondly, if you're doing a will, you don't want to register it in India, then if you're in this country, then go to the Indian High Commission to get that stamped. I would suggest that. Just don't leave it that you've written a will and it's signed by 2 witnesses. Of course, it can be executed in India, but it will lead to a lot of issues when it comes to the evidentiary value of that will.
Okay.
So either if you're in India, get that registered. If you cannot travel to India, it's not an issue. You can go to the Indian High Commission to get it stamped.
Good Lord. Okay, I had no idea about that. Okay, now are there any specific requirements around the format or content of a will for non-residents in India?
There is no format. It's like it has to be as per the Indian standards. Like I said, mention all your assets, categorically mention. If you have 3 sons, categorically mention that the house goes to so-and-so, the bank deposits go to so-and-so, which bank deposit will go to so-and-so, whatever. It has to be mentioned. And when I'm talking about, Jeet, we just, before this, we were having a conversation. This, when you talk about wills and assets, I'm not only talking about land and property here. I am also talking about your fixed deposits and money lying in India. That is one of the main concerns of people who are living here. Today, I meet lots of people who are only with one issue, is their money in their bank accounts, and we did take it up on the last talk show as well.
Yeah, with Hermina, yeah.
Yes, this is one of the main issues. People just think that they can go to India and get their money, whether it's just set up an account or you can withdraw the money and get it to this country. Number one, there's so many regulations of transferring money, and for the wills also, if your parents have left your proper fixed deposit and there is a will, you will have to go to the court to get the money out from the bank.
Wow. Okay.
Coming back, putting what things you need to put on: all your assets, all your legal heirs, the reasons of not giving property to your legal heirs, and whoever you're cutting out of the line of succession, you should clearly mention why you're not doing that. 2 witnesses, and should be stamped by the Indian High Commission. And if you are going to be in India, get it registered. That's it. And you must mention it to your spouse or somebody that, I have made a will. It should not be that your children keep looking for the will, that,
Right.
my father might have made a will. And most important, the witness to the will cannot be the beneficiary of the will, or let's say it's your son. Your grandson cannot be the witness, because if something happened to your son, your grandson will step into the shoes. So it has to be 2 witnesses who have to be outside the family and do not have to be directly or indirectly related to the beneficiaries at all.
So basically, someone who doesn't stand to gain anything financially.
Yes.
That is. Yeah.
Correct. And preferably what I would suggest and advise is, let's say if you have 2 daughters who are willing to give up their right in their property, who have nothing to do, they should be the witnesses to the will. Because they know what the contents of the will are. They are already agreeable and they are consenting to something their father or their parents are writing to their brother or to another sister or whatever. So people you're cutting out of the line of succession could also be the witnesses to the will.
Very, very, very profound, very interesting. Thank you so much, Monisha. I think this has opened my eyes. Currently I don't have any children or anything. I hope so. But yeah, this has really, really opened my eyes, and I'm sure it's opened a lot of eyes out there. Thank you so much.
You're welcome. You're welcome. And Jeet, we're not only concentrated to Punjab, we work across India.
Yeah. No, yes, I understand that you have your operations all over. You can handle any problems anywhere.
Yes, anywhere in India.
All right, perfect. Thank you so much. And it's great. I hope to see you soon again so I can learn more about this. Thank you so much. Farhan Akhtar and Shraddha Kapoor with that beautiful track. As they say, Moshi Moshi. Actually, both of us are actually fans. So, Monisha, I understand you're around for a little more time, aren't you?
Yes, I am here till the 23rd.
23rd. So,
Yes.
basically, that's just 8 more days.
Correct.
And what are you offering?
We're offering free consultation to anybody who's got anything to do with India, except immigration. I can help you on everything. So yes, they can contact us on my number, which is 11-220-9963 or 020-389-3869. And you can email us on kenya@legalhelpnri.com.
That's it. So I got to say, I think just this week alone, we've talked about banking, we've talked about wills, and I think you've given so much information, and the fact that you're actually doing it free, speaks in volumes. So ensure that you contact Monisha Mahajan right away. Thank you so much, Monisha.
You're welcome.
It was an absolute pleasure. Hope to see you soon.